Criminal trespass. What is it? How do you know if you've actually committed the crime of criminal trespass? Hi, I'm Jeff Hampton with the Fulgham Law Firm. Today I want to talk to you about the crime of criminal trespass. What is it? What does Texas law require in order for someone to claim that you truly trespassed on private property? By the way, if you wait around to the end of this video, I'll also send you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Okay, criminal trespass. Now, we all know what this is. Someone will say, you're trespassing on my land. Get off my land, right? But when does it become criminal? When is it not more than just a threat? When can the police actually get involved? And when can you actually be arrested for it? Now, in order to know what the answers to these questions are, we need to first take a look at the Texas Penal Code. Under Texas Penal Code, section 30.05, a person commits the crime of criminal trespass if that person knowingly enters or remains on or in the property of another, including residential land, agricultural land, a recreational vehicle park, a building or an aircraft or other vehicle, without the effective consent of the owner, and the person, here's the key, number one, had noticed that the entry was forbidden, or received notice to depart but failed to do so. Now, what does all that mean? Once again, you've got all this legal language. You got to break it down. Essentially, it is the decision to knowingly enter into a place or residence you know that you're not supposed to be. Now, I know I'm really just narrowing that down and overgeneralizing it. But one key element of the crime of criminal trespass is that you must have had proper notice. And we're going to really break that down here in just a minute. Merely being present on the property of another person by itself is not sufficient to convict someone for the crime of criminal trespass. So let's break down the elements. Well, first question is, what is proper notice under Texas Penal Code section 30.05? Well, under this particular provision, under Texas Penal Code section 30.05, the law provides the specific set of circumstances for how notice can be given. So proper notice means what? It can mean oral or written communication by the owner or someone with apparent authority to act for the owner. So number one can be oral communication or written communication. Number two, fencing or other enclosure obviously designed to exclude intruders or to contain livestock. Okay. Number three, a sign or signs posted on the property or at the entrance to the building reasonably likely to come to the attention of intruders, indicating that entry is forbidden. Then you have the next option is the placement of identifying purple paint marks on trees or posts on the property, provided that the marks are vertical lines of not less than 8 inches in length and not less than 1 inch in length. Placed at the bottom of the mark is not less than 3 feet from the ground or more than 5 feet from the ground. Now, I could go through this and you'll just not listen to anything that I say. The reality of it is certain agricultural places that you've got to have certain paint marks mean certain things. And most people have no idea what that is, but that's what the law is defining as proper notice for that. Finally, the visible presence on the property of a crop grown for human consumption that is in cultivation. That means if you see a big field out there where there's crops on there, it's presumed that is plenty for you to know that you do not have a right to be out on someone's crops, okay? That's one example that you can tell that's a Texas provision, right? Adding that in for crops in our agricultural land, all right? Now, what if you were on a piece of private property and had no idea that it was private or that you were prohibited from being on the property at all? Here's some of the questions. Were there any clearly visible signs surrounding the property? Did the owner convey to you orally that you were not to be permitted to be on the property at all? If not, you did not have the proper intent to be on the property with no notice. How can you have been criminally trespassing if you didn't receive adequate notice according to the law? So how do you know, and I'm breaking these down. First thing we looked at is what is notice. Well, how do you know you have, quote, entered into or onto the property of another person? Texas law requires that you be completely on the property of another without their consent and that you receive adequate notice in order to be convicted of the crime of criminal trespass. For example, we've seen people get mad and say, you're approaching my property, get away, you're trespassing. No, you have to actually be on their property. Or you could reach a portion of your body into a vehicle or a portion of your property over onto a piece of land. And being partially on someone's property is not being on someone's property. You must be completely, your whole person must be on their property in order to meet that definition of enter onto the property, okay? So that's just what the law says. Now, the question is, and everybody asks me this, is criminal trespass a felony in Texas? Now, fortunately, no, it's not. Fortunately, it's not a felony. But in order to determine what class of misdemeanor you're looking at, you need to break it down. It depends on where it was that you were trespassing. So the most basic of all criminal trespasses is the criminal trespass of a building or just someone's basic property, non-habitation, not someone's residence. And that is a Class B misdemeanor. A basic criminal trespass is a Class B misdemeanor punishable by up to 180 days in jail and up to a $2,000 fine. Now, if you do criminal trespass on a habitation, someone's residence, you are now talking about a Class A misdemeanor punishable by up to 1 year in the county jail and up to a $4,000 fine. So people ask the question, how do I get a criminal trespass case dismissed? Is there a way to get it dismissed? Well, in order to get a case dismissed, you need to have some good legal defenses, right? So let's examine a few of those. Number one, maybe you had effective consent to be on the property. Did you have consent to enter or to remain on the property? Remember, the state of Texas must prove beyond a reasonable doubt that you knowingly entered the property without the effective consent of the actual owner. Now, maybe there were instances, and here's where we see this happen on occasion. Maybe there were instances where you had been given permission to go to that property. Maybe there have been many times where you had been allowed to do certain things in the past. And a winning argument sometimes that can get a criminal trespass case dismissed would be to provide evidence of prior consent, to get that to your criminal defense attorney, to be able to show that there are times when the owner had no problem with you accessing that property, and that type of evidence could establish that you had a good faith basis to believe that you could be on the property again, okay? Now, what if you initially had consent to enter the property, but the owner claims to have revoked that consent? That happens sometimes too. Well, was the owner's revocation of that consent clear and unambiguous? In other words, were they definitive about the fact you weren't allowed to come back? For example, we represented a client that had been arrested for criminal trespass where the owner became angry with our client and just said, forget it, I'm done with you. I'm not talking to you anymore. I don't ever want to see your face again. Now, the homeowner then called the police and claimed that he had told our client to leave his house and that he no longer had consent to be on the property. However, the statement that had been given, and fortunately this was recorded, the statement that had been given it was very ambiguous. It was not clear. It did not say you must leave my property. And as a result of that ambiguity goes to the defendant, the person who's charged. The state has the burden to prove everything. The person, the accused, has no burden to prove anything at all, okay? Now, what if notice was improper? We talked about what notice is, right? We talked about what the law defines as notice. Was it proper notice under Texas criminal trespass law? For example, was the sign posted on the property reasonably likely to be noticed? That's what the actual statute says, right? Was the signage posted regularly along the property as required by law? If there is a reasonable doubt about that notice being proper, you may not have a trespass case at all. I'm going to give you a quick example before I wrap up this video. We represented a client that was arrested for criminal trespass because he and his son were fishing on someone's private property. However, the client believed he was on public property based upon this private property being right next to a public park, and there was a sign posted, but the problem was that the sign was posted on a tree where foliage and brush and all these other things were covering that area. And of course, we argued that from the pathway that our client took to get to the pond, there's no way he could have seen it. It was not reasonably able, or what did the law say? Reasonably likely to be noticed, right? That wasn't able to happen here. No one reasonably would have been able to notice that actual trespass sign, the no trespass sign, okay? So as a result of that helped our client be able to resolve his case in a way that he could get it off his criminal record. All right, now here's the goal. If you decide to work with the Fulgham law firm, our goals are always the same. At the Fulgham Law Firm, our goal is to try to do everything that we can to help our client stay out of jail, number one. Number two, to to do everything that we can to get their case dismissed. And then number 3, to make sure they can get it off their record. And so if the police or the facts the police did something improper or the facts do not support your charge, your case should be dismissed. But even if you did do wrong, particularly if you're a first-time offender, a good criminal defense attorney can many times get you what's called a conditional dismissal. And a conditional dismissal may involve you doing a few things on the front end, maybe some community service, maybe a class, maybe a donation, in exchange for your case being dismissed so that you can get it permanently removed from your criminal record. Okay, see, these are some of the things that you want to be aware of. Now, maybe you or a loved one is facing a crime of criminal trespass, and maybe you're in a place where maybe you were arrested in North Texas area, in the Dallas or Fort Worth area. And I want to personally invite you to contact the Fulgham Law Firm. This phone number that's above me, that's been up there the whole time I've been talking, I want to encourage you to give that number a call. Ask to speak with one of our attorneys. We'll be happy to give you a free case analysis and a free consultation. And I promised you if you waited around to the end of this video, I'd also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. All you need to do is click the link down below. Be happy to send that over to your email. And I want to thank you for joining us here today. I hope you've enjoyed what you heard. Maybe it's helpful. If so, share this video, like the content, subscribe to our YouTube channel, and we'll keep sending you more good content just like this. Thanks again. We look forward to seeing you next time.